There we go. All righty. So Jeanette has started the recording. So first of all, welcome everybody. Thank you for joining us for this quick seminar put on by Will Webb. He is with the Idaho Legal Aid Society or Legal Aid. um, Maybe adding more words there. This is our first seminar for the 2024 Boise VA Employee Wellness Challenge. So thank you so much, Will, for joining us. We appreciate it. So I will let you go ahead and start sharing your screen if you like.
Sure. Thank you so much. Let me see how I can do this. I want to see if you can, let's see. Um, aha, doesn't want to share what I wanted to share, which is this. Let's see. How do I share my PowerPoint? It's not letting me do it.
Well,
Let's see.
open if you have it open,
I
and then when you
do.
click share, it should give you, you could click it.
There we go. Good call.
Thank
All
you.
right. And then I will do this. Okay, that's me. Will's by Will Webb. So how much easier can it be? I'm going to go ahead and let you all know my
Oh,
email address is willwebb at idaholegalaid.org. Um, and if you want to send me questions afterwards, that's totally fine. May not answer right away, but I'll answer as soon as I can. So I'm going to try to make this fairly quick. I'm going to start off with one thing in particular. Most of you could probably do your own wills without a whole lot of help from an attorney. If you have either at-risk housing, meaning you don't have a paid off home and you can, you have trouble sometimes making your payments on everything, we could probably do your will for you. Or if you're what's called a vulnerable adult, and we can talk about that offline if you want to. If you have a kid that's trying to snake some money from you, we could certainly couch it that way. But we have 2 grants that enable us to do wills for people. And so those are the kind of the 2 factors that I can usually squeeze somebody in under. It's not too hard to show one of those 2 things potentially. But if you're flush with cash and no worries in the world, we probably can't help you. But good news is you probably don't need a whole lot. So why do you want a will?
hey, Will, can I interject for just a sec? I
Please,
think
please.
I think you were sharing your other screen. I'm seeing your slide 7 for tips for will drafting on our side.
Oh, that's not good. I'm not, let's see here. That's not good at all. Thank you for pointing that out.
I'm sorry to interrupt. Yeah.
No, please do. I don't have my 18 or my 20-year-old here to help me do this. So I had opened it. Let me try it this way. Let me um,
And
try
while
this.
Will's reloading that, guys, I threw his email address in the chat for you guys as well.
Well, this isn't doing what I want it to do. Well, I'll tell you what. We can just look at a blank screen. I don't know why in the world it's not. It says I can share a window.
Okay, so yeah, so share the, you can share either a screen or a window, and you can do the window with your PowerPoint.
Is that showing my PowerPoint at this?
I see your Teams, yeah, so not your PowerPoint.
I am not liking this. I am so sorry.
Sorry, guys, for our technical difficulties. Give us just a sec.
Yeah, that would be my technical difficulty. You know what? I'm just going to go through this. You'll get it all orally. Sorry. But I will tell you what I'll do. I will send you the PowerPoint, and you
Great.
Anybody that wants it, you could share with them. Does that work?
Thanks, Will. Yeah, that sounds great.
Okay. Most of this stuff is on the PowerPoint anyway, and you can see it, and it'll just reiterate what I'm saying. But why do you want a will? Well, simply you want a clear statement of who gets your property. You can also include your wishes regarding burial, cremation, whatever you want. All that can be in there. You can name a personal representative. That's somebody that's going to handle the administration of your estate. Typically, if you have a child, an adult child, that's a very common personal representative. You can also do a very close friend who you trust. If you have minor children, that's where you would name your guardian for your minor children. God forbid you and your spouse die in a car wreck. You want somebody that you trust to help raise your minor children if you have those. One thing, if you don't have a will and you die intestate is what they call it, the state will determine your heirs if you have any. Usually that's your spouse would be the first to take your children. If you have no living children, then grandchildren or your parents if they're still alive. If you don't have any relatives in that line of succession, the state may take your property, and they call that escheats to the state. And the word cheat is right in there, so you can figure out what that means. So you definitely want a will, especially if you don't have somebody right in that line that's going to take if you don't have a will. One thing that I see a lot on television shows and especially commercials is the scare tactics about probate. Oh, you want to avoid probate at all costs. I disagree with that. Probate is really not usually much of an issue for anybody. When is probate an issue? If you have somebody that's going to contest your will, it might be an issue. If you have a huge corpus of money and property, it might be an issue. But I'm guessing most of the people on this call have maybe a home, some assets, but we're not talking about tens of millions of dollars. Unless you have a ne'er-do-well child that's going to do whatever they can to get their hands on some money or something of that ilk, probate is typically just show up, present the will, it's signed, it's executed, it's witnessed, court stamps it, you go on your merry way. It doesn't typically take too long. It'll all be done by the book, easy to defend. So I wouldn't worry too much about that. The only time you would want to do something like a trust to quote unquote avoid probate would be if you have an adult child that maybe can't take care of themselves for whatever reason. Maybe they have autism. Maybe they're just, not of sound mind to manage their own affairs. You might want to do it at that point, but just let me say, trust costs money. I can't do them. I don't do them. They're fraught with tax implications. So you would have to pay an attorney probably somewhere in the neighborhood of at least $5,000 to do a trust for you. And 95 times out of 100, they're not needed. You can do everything you need to do with a simple will. So there's some terminology you need to know. Testator, that's the person that's doing the will. You're the writer of the will, the testator. Used to be called a testatrix for a female. We've done away with that archaic language. It's just all testator. The estate is whatever property you own. And then your personal representative is what we used to call the executor of the will, but they call it a personal representative here in Idaho. And that's the person that just basically would run your will through probate if necessary and distribute the property under the will. Most people name one of their children who is taking under the will. That's totally fine. I typically recommend against naming two people as personal representative because you want one person to have that responsibility. You could name an alternate, however. My son, James, unless he's living out of the country, and then if he is at the time of my death, it'll be my daughter, Jane. You can do that too. I typically, again, recommend against naming two at the same time because they would have to agree and that could create some tension. You basically have to do a statement of testamentary intent, and this is all going to be in what I send out, so you'll have it. Your name in there, of Ada County, Ohio, Idaho, sorry, can't believe I did that. Ada County, Idaho, or wherever you live, being of sound mind and not acting under fear, fraud, duress, or undue influence. Make my last will and testament. I have a case right now where I did a will for someone, and it seems like their former husband at the time of death is going to contest it. So I'm going to have to say, no, I was there and she was totally coherent, and I believe that she was of sound mind and not acting under fear, fraud, duress, or undue influence. Uh, Typically, you can write a will, you can handwrite one. I recommend against it because there would have to be proof that all the important parts of the will are in your handwriting, and somebody would have to come in and testify to that. Kind of a pain in the butt. I typically say type them all up. Uh, you have to have your statement of intent we just discussed. You have to name a personal representative. You have to list how the property is to be distributed, and we'll talk about that in a minute. You must sign and date it, and you're going to do it in front of a notary, and you're going to have two witnesses that are going to also attest that they witnessed you sign the will and they were witnesses to it, and that you were apparently of sound mind and acting without duress and fear and that sort of thing. One recommendation I have is I do not have anybody taking anything under the will sign as a witness. You want to keep that clean. You want your witnesses to be disinterested parties, somebody that doesn't take. I've had a couple people actually ask me, hey, can I leave part of my estate to legal aid? That's very thoughtful. Thank you. I'm not going to write your will if you're going to do that, though, because it's not appropriate for me to write a will when the company I work for, the nonprofit organization I work for, Idaho Legal Aid Services, Inc., is taking something under that will. I don't feel comfortable with that. So I would refer you to somebody else, hopefully do it for free, and you could do that. So anybody taking under the will, I would have them not be a witness to the will. That could gum things up later. I will send you the language for naming a personal representative. It's very easy to do. So when you're drafting your will, what do you want to do on the front end? Like the tips for starting. One is you want to make a list of your property, especially real property, any real property you own, whether it's bare land, it's a house, it's a condominium. Please make a list of that. If you have more than, say, $100,000 in assets, you might want to consider having an attorney draft your will, or at least have one look at it. Like I said, if you qualify under our guidelines, I'm happy to do it for free. We don't charge anything. So if I can fit you in under a grant, I'm happy to do it. Wills are fairly easy. Happy to go over it with you. Remember to name a guardian if you have minor children. I hate to keep stressing that, but that's important. When you're referencing your real property, I would, if you're able, use both the legal description and the address, the mailing address of the property. And that'll give you, the legal description would be the lot number or whatever that's on your deed. And then, of course, the address is whatever the address is where you would send mail to that piece of property. One thing I didn't mention yet, but I should, is you're going to leave your personal property. You can either do it set forth in the will, or you could attach a document to the back that says, okay, all of my Hummel dolls go to my daughter, all of my record albums go to my son. You can do that either in the will or in a separate document. If you do it in a separate document, you have to reference that document in the will, and I would sign in front of witnesses that separate document in front of a notary and attach it to the will. That way there's no ambiguity about your intent. If there's just a handwritten document on the back that you staple on there, people could argue that you didn't intend that to be on there, that sort of thing. So you want to do it in a more official way. But if you have a separate sheet, it's easy to tear that off, tear it up, and do a new one, revoking all others. And that's an important point too that I want to mention. When you're drafting a will, one of the things you also want to do is revoke any and all prior wills and codicils. And codicils are basically amendments to a will. So a codicil would be, oh, since I drafted this will, my Aunt Jean has died, so I'm taking her out of the will and leaving her stuff to somebody else. You could do that in just an amendment without having to draft a whole new will. But what you're doing when you're making a new will is you're revoking all the prior ones. So this one moving forward is the only one that counts. You can also have what's called a will contest clause. For example, say you have 3 kids. I'll use me as an example. I have 2 sisters. One is ne'er-do-well and the other one's a very decent person. The ne'er-do-well, my father, he died 20 years ago, but wouldn't have wanted to leave her anything, or maybe a very small amount. So he might have said, I'm going to leave her $5,000, but if she contests the will, she gets nothing. You can do that. That would usually prevent somebody from contesting the will in probate if you leave them something at all substantial. Another point that bears saying here, and hopefully this doesn't apply to many of you, but it might. Say you have 3 kids like my parents do or did. Say you want one of them to not take under the will, but the other 2 to take under the will. So say my dad would have wanted my sister, my good sister, and I to split the estate 50-50, leaving my oldest sister with nothing. And there's a reason for it. She's just not a good person. Well, you can do that, but you got to be careful. You have to specifically mention the child that is not taking under the will, acknowledge their existence, and state your intent to not leave them anything. Because if you don't mention the child at all, she could say, my oldest sister could come into court and say, Dad plumb forgot about me, but he meant to put me in his will. And if you're not mentioned at all, that's a plausible argument. You can't do that if Dad said, I know I have this daughter and she's a bad seed and I intentionally am leaving her nothing. You put that in there, she's toast. What other people do, and I think this may be a little bit more cruel, they'll leave them $1. I have this other daughter, I'm leaving her $1. That's almost a slap in the face, even more so than telling them they're not leaving them anything. But if you have an heir and you're leaving it to some of the heirs, but not others that are in your direct line, I would mention the heir that you're leaving out and put in there that you're intentionally leaving them out. You don't have to put a reason. You can if you want, because they broke my heart, because they wouldn't quit using illegal drugs, whatever it is. You can put that in there, but you don't have to. After you have your will done and you think you've left everything you have, you'll still want to include what's called a rest, residue, and remainder clause. Yes, that's that stupid legal thing. Why do we have to put 3 words on it? You could just call it the residual clause. It's what I would like to call it, but they call it rest, residue, and remainder. Basically, all that says is, I know I've left all this stuff above to people, but if there's anything else left, it goes to so-and-so, right? And it'll say, I give and devise all the rest, residue, and remainder of my estate of whatsoever nature and wheresoever situated to, John Smith. And in the event that John Smith not survive me, then you can leave it to somebody else. All that does is, if you haven't specifically mentioned a piece of property, say you forgot that you had 5 acres in Whistler. I don't know how you'd forget that, but say maybe you did. That would go to whoever was in the rest, residue, and remainder clause, because it didn't pass specifically under a bequest above. So you want to do that. And that typically you can divide that up between your heirs. If you have 3 great kids, you could say the rest and residual will be divided 3 ways equally by my children. If anybody's got minor children, they can call me and I can help you with the guardianship language. Most people that do these will seminars, I've done another one of these at the VA last year. I don't think anybody had minor children, so I'll skip over that for now, but you can ask me offline if you'd like to. Let's see. Talked about probate. If you have a very small estate, and I don't remember the exact figure, but I think it's certainly less than 50 grand. That can be done, it's probably 100 grand actually. That can be done under what's called summary administration. It's basically filing saying the estate's worth less than a certain amount, and it'll fast track it through the courts. If you have a situation like that, just call legal aid, get on my hotline. I can help you with that. It's not super difficult to do. You can do it yourself through the court assistance office here in Ada County or whatever county you're in. It's just a little bit quicker way of doing it. Typically, if you have any real property, though, the summary administration is not available to you. You'd have to go through the typical probate process. And while we're on probate, let me just say one thing. Most of the things you have will not even go through probate. Usually that's mostly real property. If you have bank accounts, if you have retirement accounts, you don't mention them in your will and pass them the way you want them passed, but you don't even have to use the will for those. You name a beneficiary. So I have my retirements with Vanguard. On my Vanguard account, I listed both of my sons. They're both adults, 18 and 21. Each of them get 50% of my retirement. If I die tomorrow, they don't have to mess with my will. They just have to get a certificate of death, present it to Vanguard, and Vanguard will give half my money to one son, half to the other. At your bank, and if you haven't done this, I highly recommend doing it, file a POD. That's payable on death. All that is you go to your bank and say, I want to do a POD, naming my daughter, Jill Smith as my POD. So if you do that, the bank keeps that on file. You tell your daughter, Jill Smith, that. After you die, she takes your death certificate to the bank and says, here, you've got a POD for me. Here's the death certificate. I think pretty much that day, it may take the bank a day or two to process, but she should have access to the money in your account virtually immediately or within a day or two. I think that's a very smart thing, because if you have a daughter that's, say, 22 years old, just starting working, just starting her life, she doesn't have any money. If you die, there's going to be expenses. If you do a payable on death at the bank, she can go and use your checking account and your savings account to pay for your funeral or to pay for your cremation or whatever you want to do. And it's a way that money can pass directly to her without going through the probate process. And that's true for almost any account you have, any savings account, checking account, investment account, retirement account. Almost all of them have a beneficiary that you can name. And so your money would pass that way. I would put it in the will as well, so there's no confusion. But if you have a beneficiary name, that usually trumps. So you're okay with that. There are some resources that are at the end of this PowerPoint that I'm going to send. Mostly to our website. We have questions and answers about wills. We have question and answers about what's called holographic wills, which is in your handwriting. Again, unless you're really wedded to handwriting your will, I highly recommend against it. It's just a lot of difficulty in proving the will at that point. We have some questions about probate, but at the end of the day, I think the most important thing is if you read through this and you feel like you can do it yourself, please do. But if you want help in preparing a will, and we can qualify you, and I'd say we could probably qualify most of you. We'd have to ask some questions, of course. You can come through me, and I can certainly help you prepare it. I did see a question, and I think it's in the chat. Let's see. I can go through some of these. So let's go from the bottom up. Is a POD necessary if you are a signer or listed on the account already for a senior parent? No, it's a great question. In fact, my dad added me as a signator of the account before he died. So he didn't need a POD. I could go, I went up, and my mom, not the greatest person with finances, I got all of their estates kind of transferred to her, everything done perfectly. And I did that without need to do anything because I was already on the account. Minimum age for a POD, I'm going to assume is 18. I think you have to be a legal adult. I don't know that you can do a payable on death to your minor child. You could do it to the guardian for the benefit of the minor child, but I don't think you could leave your accounts to a minor child. You could leave it in trust to them, but that's, again, trusts. Another word, you'd have to probably speak to an attorney about doing a trust if you have a minor child and you want to leave them money that way. Let me go to the top here. Ooh, there's a lot of them. Let's see. Okay. If a person has a power of attorney with no end date, can they create a will even though they are of sound mind at the time? I got this right. You can give somebody a power of attorney to handle your finances or to make medical decisions for you if you're incapacitated. Just because somebody has a power of attorney, that doesn't mean that you are not of sound mind. Now, if they have a power of attorney because you weren't of sound mind, you may have to prove that you were of sound mind when you made the will. Does that make sense? But I have a power of attorney for my oldest son. I gave it to him just in case I'm in a car wreck and I'm in a coma and never going to come out of it. he has the authority to pull the plug. So I'm just going to say it that way because that's the truth. That doesn't mean I'm not of sound mind. So just, as long as you're cogent and can accurately state, here are my heirs, here's what I want done with my property. Nobody's forcing me to do it. So you can do that. So special needs adult children. Yeah, that is one, I think, where you might want to consider a trust. That's one of those situations where a trust might make sense, because you want that money somewhere that's going to be for the benefit of your adult special needs child, who I'm going to assume can't really manage the money themselves. I have two nieces. My sister made me their guardian in the event that she passes away, and made a trust for them because they're sweet young ladies. They both work, but they're not really good with money. They both have some learning disabilities. And so I'm going to manage their money for them. If my sister predeceases me, she's 11 years older than me, so she may. And so she did a trust for them. And so that's one area where a trust may make sense. If you have an adult child that probably will not be able to manage their money effectively by themselves, you'll need a trustee, somebody that you trust. I'll keep using that word, to help with that. You would have to go through an attorney to do that. An attorney that specializes in trust. You might be able to get a deal, but I would plan on several $1,000s to create a trust, mostly because there are a lot of tax implications with a trust, and whether it's revocable or irrevocable. Very complicated area of the law. It's about all I can tell you at this point without getting all out of my comfort zone or wasting another 20, 30 minutes of time. So hopefully that helps. Let's see. My father added me to his property deed. Yeah. I'm not sure if that's going to enable you to avoid taxes. I don't know that it's a bad idea, but what you could run into, and this is too a little worrisome. If the property is worth a lot of money and the IRS deems that a gift to you, you may owe taxes on that. I don't know what the gift limit is. It used to be $10,000 a year per person per child. So I could, in theory, I'm not going to do it. They can work for a living, but I could gift my children $10,000 a year. I don't have it, so it's not going to happen. Without tax implication, I could do that. So be careful about that, because if he's adding you as somebody to avoid probate, it'll probably work. If you're on there, then it's your money, but he needs to leave it to you in the will. Because if the will says something different and you're named on there, that's going to be a big fight. So, but if you're the one that's taking under the will and he's already added you on the deed, you're probably fine. But I would be very careful of that, because if the IRS comes in and looks at that and audits you and says, hey, here's this 500-acre piece of property that's worth $1 million, and your dad added it to you on the will, on the deed, since he's still on it, probably not a gift because it's probably still his. But the gift tax is pretty onerous, and it's for a small amount of money. The estate tax, I don't think anybody on this call, well, maybe, hopefully some of you will, but I don't think anybody's going to be hit by the estate tax, because it used to be $800,000. Now it's, I think, 10 million. So if your estate's worth less than 10 million, there's no tax. There's no estate tax. So leaving it under the will is I still think the way to go. And somebody said there's an attorney in town who specializes in special needs trust. Well, if you want to put in the message who that is, that would be great. I don't know who it is, but I'm sure I could probably figure that out at some point. You might be able to just do a Google search for that. Here's an interesting question, and I'm going to be the first to say I'm not sure the answer to this. I'm going to give you my best guess. I clearly listened to too many murder podcasts. I have custody with my ex, and we have a minor child. Should we both pass while he's a minor? Whose will would be followed if we wanted a different person to be their guardian? That's a tough one. Probably in that case, what would happen is who died first? And it would be the person who died second that would control in all likelihood, unless you're talking about something that would happen in a murder podcast, and then maybe not. So I'll just speak hypothetically. I have an ex-wife. Let's just say my youngest son is 17. He's 18. Let's just say he's 17. She wants her mom to be the guardian. I want my mom to be the guardian. That's not true for either one of us because my mom's old and her mom's crazy. So neither one of us would want that. But say she comes over and she kills me and then does a little murder suicide. Would her will count? I don't think so, because she has unclean hands. She killed me. So I think in that situation, it would be my will would govern. Hopefully that's not a situation that we're dealing with here. So if you both happen to die this weekend, God forbid, whoever dies second, their will should count, because if you predecease your ex-spouse, at that point, he gets the kids. If he dies 10 minutes later, well, he had custody of the kids. So I know you don't, thank God, but thanks. So the person who dies second would actually control under that scenario. I'm 99% sure. Never had this come up. I've never litigated this. I've never researched it. So my answer could be wrong. But my suspicion as a lawyer of 30 years who's read way more cases than he wants to, that would probably be what happens, because the court would look at who had the authority to name a guardian at the last possible time. And it would be the person who died secondly. Anyway, that's it for my time. I'm so sorry that we ran over. I will email this to Lindsay and let her forward it to you. Is that okay, Lindsay?
Yeah, that's perfect. Yeah, or myself or Jeanette. Thank you
I'll
so
email you
much.
both and you'll have it. And I'm so sorry I couldn't get that to work. It'll be nice fodder for my 21-year-old who lives with me. He can laugh his butt off about dad not being able to share a screen. So there you go. You've made my son very happy today.
That's funny. Well, thank you so much. Well, we appreciate you giving this presentation today. I am just going to share my screen with our little disclosure here for YouTube. I'm assuming everybody sees it.
Yes.
Okay, excellent. Good deal.
Somebody asked for my nice, don't leave your son anything. I wish. Somebody asked for my contact info. I just put my email address up. I think I spelled it right if you want it there. Yeah, please just shoot me an email. You can also call and get on our hotline, and I can answer questions that way too. Happy to do either one.
What is the phone number for the hotline?
That is a great question. You can call the main number. It's 208-746-7541. And I will go ahead and type that in while we're
I just
here.
did. I typed it right when you were talking. So did Jeanette.
Well, thank you so much. And please, anybody, if y'all have any questions, just reach out. And again, the last time I did this, I did probably 3 or 4 wills for people. They were shocked that I actually didn't charge them. We don't. We're not for profit. We're all grant funded. We do have a VA grant that enables us to do some of this, not all of it, but some of it. And so happy to help you. I come from a long line of veterans. My service was with the Foreign Service. I was a diplomat overseas in Afghanistan too for some time.
Wow.
So, but I did not serve in the military. My dad correctly pointed out, you're not good at taking orders. Anyway, thank you all. Right. And it looks like we had a good crowd. So if you need anything from me, just please let me know.
All right. Thank you very much. And
thank
that concludes the session. Thank you, everybody, for joining us. We will talk to everybody on Monday morning at 8 a.m. Thank you.
Bye, everybody. Thank you.
Bye. Thank you.